I'm here in a limited capacity. See how limited my capacity is? I'm the president of the McCormick Society, and we welcome all of you to this, the 39th, I believe, annual McCormick Lecture. The McCormick Society honors J. Byron McCormick, who is both president and dean of the college. The important thing for all of you from the community to know is that the lectures have been sponsored by, made possible by, entirely by the beneficence of the members of the society who believe in the importance of ideas and sharing them with the wider community. Anybody's welcome to join. There's a contribution to the endowment which sustains all expenses of this evening and enables you to come to dinner with us at your own expense because the important thing is making it possible for you to meet people like Mr. Liptak. Last year it was Elena Kagan. Next year it will be Dean Chemerinsky, who's the new dean at Berkeley. If you look at the brochure, you'll see all of the people who come here. I would like to just take one moment to thank the society. Would you please stand so that we can give you our gratitude. Will introduce our speaker. Enjoy. I hope you have a good time tonight.
Thank you, Tony. Thank you, current members of the McCormick Society. And given Tony's invitation, thank you, future members of the McCormick Society, and indeed all of you who have joined us to hear a singularly important voice for our times. We're delighted to welcome Adam Liptak, his wife, Jennifer Bittman, to the best climate, and at the University of Arizona, the college, and the state, to the best intellectual climate in the country. As many of you already know, our speaker started his career at the New York Times as a copy boy. Yes, that is what they called it. So I think back to movies like His Girl Friday and Citizen Kane, and I see this image of a lad in a beret sprinting through Manhattan streets, delivering coffee to the press room, fetching coffee, jumping to the ready whenever an editor barks. Adam Liptak's friend, former New York Times editor Nancy Sharkey, who joins us with her husband Joe, today offers a more colorful description. As I recall, he was one of those kids who had to go into the Times Square in those crack years, dodging broken vials, drug dealers, and prostitutes to get to a newsstand called The Deuce, to buy copies of Newsday, the Daily News, and New York Post hot off the presses at 9 p.m. so the Metro night editor could see where we'd been beaten and by whom. As reality would have it, when he joined the New York Times in 1984, Adam Liptak had already established his credibility as a journalist, having served as an editor at the Yale Daily News, the daily for the school from which he graduated, with a degree in English, cum laude no less. Many years later, describing the experience, he said his early start was not exceptional, noting a lot of terrific people, no small number of them with fancy degrees, came through the Copy Kid program. In the same article, responding to a question posed by a New York Times reader, Adam sought a quote from his father on the topic of his Ivy League son moving to from the top of the Yale student hierarchy to the ranks of Copy Kid. Bill Liptak said, "I was very glad. I knew that Adam will not like the business world, is articulate, good at writing, and can tell right from wrong. I also knew from my own experience that it matters not where and what position one starts in life, if it is the right road, and the Times was the right road." Returning to Yale for a law degree also proved to be the right road. During his law school years, he clerked in the Times legal department during the summer. After graduation, he spent 4 years at Cahill, Gordon, and Reindel as a litigation associate, specializing in First Amendment matters. In 1992, he returned to the Times legal department to advise the company's various newspapers, television stations, and news media outlets. A decade later, he rejoined the Times news staff. No longer a copy kid, but now the national legal correspondent of the most powerful journalism institution in the world. As such, he covered the country's most compelling trials and reported stories that form our understanding of the workings and the inner workings of law. This includes the nominations and confirmations of Justices Roberts and Alito, the trial of John Lee Malvo, dramatic changes to our criminal justice system, including debates over capital punishment, and investigation into the revelation of Valerie Klaim's identity. He inaugurated his popular column Sidebar in 2007, which for many has become can't miss reading. In 2008, he assumed the position previously held by Lily Greenhouse when he started covering the Supreme Court. As one of our generation's preeminent journalists, his voice reaches beyond the times, and he has had work in the New Yorker, Vanity Fair, Rolling Stone, the New York Observer, Business Week, and the American Lawyer, among other influential publications. He published a critically acclaimed ebook entitled To Have and Uphold, Supreme Court in the Struggle for Same-Sex Marriage, which I should mention is available on Amazon. And as one would expect from a man of his prolific work, he has received many accolades and awards, including the New York Press Club's John Peter Zenger Award for defending and advancing the free press, Scripps Howard Award for Washington reporting, and he was a finalist for the Pulitzer Prize for explanatory reporting in 2009. So anyone involved in journalism, but I think any of us who follow journalism, realize that we find ourselves at an odd and difficult time where infotainment eclipses information, where our loftiest principles may not be as lofty or at least as universally championed as we once thought, and where our leaders are dismantling the very tenets of what it means to be governed under principles of transparency and truth, indeed, where some have forgotten even to speak about the meaning of the rule of law. In that regard, Adam Liptak is one of our standard bearers. He asks very straightforward and powerful questions in his reporting. Is it important? Does it tell the reporter something new? Can it be told in a lively and engaging way? This evening we'll have a lively and engaging conversation with Professor Jason Kreag, and they will reserve time for your questions. With that, please join me in welcoming a journalist who, without a doubt, has taken the right road, Adam Liptak.
Thank you, Mark, and thanks to all of you for coming. Adam, I'm going to jump right in with some substance. Right now before the court, there are two partisan gerrymandering cases, one from Wisconsin and one from Maryland. And this is an issue that the court developed about 15 years ago. And so the question is, why now? Why is the court interested in this issue now? And what makes it a situation where the one party in Wisconsin might have gone too far, or one party, the other party in Maryland might have gone too far in drawing their legislative maps?
That's a good substantive question, and I'll answer it. But first of all, I want to thank you all for having me. Thank you to the McCormick Society in particular. Thank you to my friend Stephen Golden for helping arrange this. And thank you all for coming out. Partisan gerrymandering is the drawing of those weird voting districts in order to advantage the party in power. So in Wisconsin, for instance, it's a purple state. The statewide state legislature, the vote is about 50-50. But because Republicans in 2010 controlled both houses of the state legislature and the governor's office, they leveraged their 50.1% advantage into like 2/3 of the seats on the General Assembly. And that kind of partisan gerrymandering affects, and in the minds of many mars, our democracy. Because the democracy is not functioning if votes aren't translated into representation. The Supreme Court, on the other hand, has never recognized claims against partisan gerrymandering. It's never said that partisan gerrymandering is unconstitutional. It does say racial gerrymandering is unconstitutional, but the court has been closely divided on this question, and Justice Kennedy, who holds the controlling vote in this case, as in almost every case, has said words to the effect of, I don't like it, it doesn't smell good, but I can't think of what standard we would apply to let us manage this thing. But this year they did agree to hear, or took appeals from, cases from Wisconsin and Maryland. The Wisconsin case has been argued. My take was that Justice Kennedy may well think it's time to say the Constitution forbids warping our politics in this way. And if that were to happen, and it may happen in June, that would be a huge step. And one reason to think they may be ready to take that step is, very unusually, they've taken a second case on essentially the same question, this one from Maryland, and this one where Democrats were doing the same thing. This is not a partisan issue in this sense. When Republicans are in power, they try to keep themselves in power. When Democrats are in power, they do the same thing. And the fact that the court took this second case from Maryland makes you think that A, they're quite interested in the issue, and B, if they're going to send a signal, they want to send a nonpartisan signal and say, it's no good in Wisconsin when Republicans do it, it's no good in Maryland when Democrats do it. And so if we were to have that decision, if we were to hear that partisan gerrymandering is subject to constitutional challenge, it will reshape American politics. It will be one of the most consequential decisions we've had in many years.
I think the justices in the oral argument in the Wisconsin case, there was agreement that it's distasteful, but I didn't hear any agreement on what the standard should be. And they're going to be faced with drawing the standard or coming up with the standard, because this case will come back to them in 2022 and 2032. So is there anything that you can glean from the oral argument about what standard might be acceptable to Justice Kennedy?
Well, I'm going to see if I can do this for a general audience, and I'm going to go into the realm of political science for a second. There is a kind of mathematical standard that some folks have proposed. The way you do partisan gerrymandering is by packing and cracking. You put all the Democrats in one district and let them have that district, and then you try to spread them across other districts in a way that Republicans have a small minority in those other districts. So the first is packing, the second is cracking, and you can tally these up. You can have what political scientists call an efficiency gap, because every vote in the first kind of district over 50.1% is a wasted vote. Every vote where your guy doesn't win is a wasted vote. You add those numbers up, you divide them by how many seats there are, and you get a number. So one idea is the Supreme Court could say, you know, if it's more than 7% efficiency gap, that's no good. Now that's not going to be appealing to a lot of people, because they're going to say, where in the US Constitution does it talk about a 7% efficiency gap? But it still could be evidence of partisan gerrymandering. More likely, the court says something like, listen, it's the usual kind of three-part test. Did they do it on purpose? Did they intend to keep their party in power, as opposed to using the usual kinds of tools you use in drawing voting districts, compactness, keeping county lines in place, protecting incumbents, or did they lean heavily on partisanship? So intent, did it work, effect, and was there some good reason to do it anyway? And that's a fairly standard legal test. And the court should need to say a little more than, under that test, this Wisconsin thing goes too far, and we'll leave for little later cases to figure out exactly, how far is too far. When the court started to say that the Constitution required one person, one vote, they didn't immediately say how much play there was in that concept, but it did say, the really outlying district was too much.
Justice Roberts referenced the efficiency gap in oral argument, and in his words, it was social science gobbledygook.
Yes.
So I think he was looking for a standard that didn't involve that, but it might also have been that he had a different audience in mind when he responded to the challengers in this case. Was he talking to someone else? Was he talking to other justices on the court? Or was he inviting this standard, this three-part standard that you've just described?
When justices ask questions, they are almost always talking to each other. So when justices take the bench, they haven't talked about the case yet. They're going to vote a day or two later in a private conference. And the main point of the oral argument, which seems like an effort to elicit information, ask questions of advocates, is really a way of talking to each other. And when the Chief Justice, Jason, made that comment about gobbledygook, he followed it up with the following observation. He said, if we're going to get in the middle of this, and we're going to say, in this case, Republican wins, in this case, Democrat wins, that's going to make the court look bad. That's going to make us look political. And I don't know that we want to get involved in this, and moreover, this whole thing is gobbledygook. And the court is particularly stuck here because this is one rare area where it has to take these cases. These cases come up on direct appeal. The court's docket is almost entirely discretionary. It gets to decide which cases it's going to hear. But in this area, Congress has said you have to hear these voting cases. So the Chief Justice was saying, one, it's gobbledygook. Two, it's going to make us look political and hurt our legitimacy. And three, it's too much work. And that was all talking to his colleagues, or more specifically, Justice Kennedy. But I think Justice Kennedy is not afraid of the bold step and might respond to, it's going to be a lot of work. That's your problem, guys. I'm here for a year or two more, and I'm leaving.
So just to clarify, do you think that there's a chance that Justice Roberts would like to see this, these two cases from Wisconsin and from Maryland to end up like the case 15 years ago, where the court essentially said, well, maybe there's a limit on partisan gerrymandering. We're not going to set a standard for it. We don't think these meet it. This is too political for our time right now, and just punt on both of these cases.
Well, I think that's entirely possible, and I think even the more, call it conservative position is possible, which is to say, this may be bad, this may be ugly, but it's baked into our political process, and the Constitution has nothing to say about it.
Let me move to a more general question about covering the court in general. So oftentimes when journalists are covering the government, they rely on leaks, they rely on people who share information with them. For the most part, we don't get this type of information from the court. There are usually very few leaks. That said, in the last several months, there have been several kind of interesting stories about Justice Gorsuch's transition onto the court that seem to have, in the case of Justice Kagan, perhaps come from conference, where there was some reporting that they had disagreements at conference. Justice Ginsburg very pointedly responded to one of Justice Gorsuch's lectures from the bench in the Wisconsin gerrymandering case. And there are even reports that Justice Roberts is perhaps turned off. So the first question is, why aren't there leaks? Why don't we have leaks from the court? And then I guess the response to that we have, and is this just the normal kind of transition for a new justice, or is something different going on with Justice Gorsuch's transition to the court?
So you packed a lot into that question. It's true that in general, covering the court is not like covering the Pentagon or the Justice Department or the White House. You are basically explaining the public acts of the court on deadline, trying to translate complicated legal materials into English. But it's not, for the most part, what many of my colleagues do, which is to find out secret stuff. Occasionally, typically book writers, typically some years later, will get inside the court and report out interesting developments. But the daily beat reporter seldom does. As for these stories about Gorsuch, it's a little difficult to talk about because it's not as though we don't have some interactions, we reporters who cover the court, with people inside the court, but such interactions as we have, you might think might be off the record. There are enough public indications of the fact that Justice Gorsuch's transition on the court has been rocky, that it's not hard to write the story that some of his colleagues might be slow to warm to him. The particular reporting about that Justice Kagan may have lectured him inside the justices' private conference, which only the 9 justices attend, I don't know that that reporting was rooted in fact. That's not to say there's not some level of tension at the court, but that particular reporting I have reason to doubt.
I think that was the least source of the, obviously Justice Ginsburg comments to Justice Gorsuch were on the bench, and she's recently spoken, I think, glowingly of all of her colleagues on the court.
I think she speaks every day, so it's a little hard to keep up with her. But I think she was at Columbia today, and if I was reading my Twitter correctly, she had a wonderful phrase saying, I respect all of my colleagues and like most of them.
That's exactly the quote I was referring to. What are we to, you mentioned Justice Ginsburg, what are we to make of her? She's on tour right now. She's, it's the middle of the term. She's visiting law schools day after day and seemingly enjoying it. Who's her audience in these sessions? What is she? What is her goal in all these public appearances?
It can't but be fun to show up, you know, in a setting like this and get a thunderous standing ovation and have people show you their tattoos of RBG and be a living icon. I don't think she's trying to convey particular things. In fact, on the whole, I think the justices are out and about a lot. They're in the midst of a 4-week winter break. The short of it is, it's not a very hard-working court. They decide 70 cases a year. There are 9 of them. They each have 4 brainiac law clerks. That means you have to write, in the course of a year, 8 majority opinions, 2 per clerk. There's time for this. It's fun. But I think most of the justices would prefer that there be no press coverage. They're not trying to talk to anybody except the room. And they don't, you know, they don't enjoy saying something controversial that then gets a lot of attention. So Justice Ginsburg and the other justices would happily have an interviewer ask them gentle questions about their background and, you know, who the junior justice is in charge of the cafeteria committee and Justice Kagan put in the frozen yogurt machine. And stories like that is what they prefer to tell.
Are they at all talking to each other in these public events in the same way that they do on the bench or when they're asking questions during an oral argument?
That's a good question, but I think the answer is no. I can think of one counter example, not in a public interview, but in an interview, where Justice Ginsburg, after an argument in a case, but while the case was pending, about a middle school student who had been strip searched in a school with a zero tolerance policy where she might have brought, but in fact hadn't, brought Advil to school. The argument looked like it was going very badly for this middle school student. And Justice Ginsburg gave an interview to Joe Biskupic, then of USA Today, saying, you know, I just don't think my colleagues understand what it's like to be a 14-year-old young woman, girl. And I don't think they get it, and how humiliating that was. And at the argument, I would have guessed the student loses. As it happened, she won 7-2. And I think that was an effort by her to send that message. But the fact that I remember it is really because it's so rare. And I don't think in these public appearances they're talking to each other. Listen, when they want to talk to each other, they write draft opinions and circulate them. I mean, there's a lot of criminology about the court, but really they communicate in writing and they try to persuade each other for reason, not by sending messages through the press, not by hobnobbing in the hallways. It's a serious intellectual enterprise, and the way they do it is to try to have the better of the argument.
Let me just push this one more step. Is it ever the case where they're talking to potential litigants, signaling that the court might be open to hear either a potential line of argument or a potential case? After all, their docket is, for the most part, cases that they select. So are they ever signaling that in their public comments?
They do signal wanting to take cases, but not in that setting. They have other vehicles to do that. The most typical vehicle is when the court turns down a case, denies certiorari, says it's not going to hear a petition seeking review. It typically just says that. It doesn't give any reasons. But not infrequently, someone will issue a dissent from denial of that petition. And in that kind of setting and similar settings, a justice will say, well, maybe not this time, but we'd sure like to hear a case along these lines. At least one big case this term about public unions was almost surely a consequence of Justice Alito saying, in an appropriate case, we might reconsider such and such decision. So they have ways of signaling, but again, they have formal processes to do it. They don't need to show up at a law school to do that.
Let me turn to another case before the court that I think impacts probably everyone in this room. Probably all of us have in our pocket a cell phone. And right now the court is considering our privacy rights in our cell phone data. The case is Carpenter v. United States. And the short facts were that Mr. Carpenter was arrested for a robbery, for several robberies.
Ironically, of Radio Shacks. So the court's going to decide the future of digital privacy rights in the Radio Shack.
But he did steal, among other things, cell phones. Had these Radio Shacks. Well, they caught him, though, in part because they got about 4 months of his cell phone data from his cell phone company to place him near the scene of this series of crimes. In much the same way that our cell phone companies could track us tonight and all the way to our home and tomorrow morning when we get up and go about our day. So the court's going to address kind of when can law enforcement get this information. Now, going into the term, you signaled that this was one of the potentially momentous cases before the court. So what's at stake? Why is this something that we all should be concerned with?
So first of all, some news you can use. If you're inclined to go rob someplace, airplane mode. This question of privacy rights in the digital era, where third-party companies have vast amounts of data about us. So these cell phone tower records are important and really will track you everywhere you go in town. And if the government doesn't need a warrant to get that information, it's an impingement on your privacy rights. But it's true of all kinds of things. It's true of Google searches. It's true of all kinds of information held by third parties. Old Supreme Court doctrine says if you voluntarily turn over something to a third party, if you dial a telephone number, and Ma Bell in 1950 knows that you voluntarily turned it over and you have no particular rights in it because it's held by a third party. This is the so-called third party doctrine. The government can have access to it and so can anybody else. I think the court is probably ready to say that in the digital era we have to rethink the third party doctrine for at least some kinds of information. The Supreme Court has already said in two somewhat similar cases that there are limits on digital privacy rights. In one of them, cops put GPS devices onto somebody's car and followed them around town. And the court said in the majority opinion, that's no good, but because of physical trespass. The court has also said that if the police arrest you and want to search your cell phone, what's on it that's in your pocket, not what's held by the company, but what's in your pocket, they need a warrant for that. So you have a court, and by lopsided majorities, in fact, unanimously in these two cases, although in somewhat differing theories, is alert to Fourth Amendment privacy rights in the digital era. I think it's quite possible that Mr. Carpenter wins, and moreover, that the court revises this quite established doctrine in a way that will give us more rights in an era when so much is known about us that if the court goes another way, you want to be a little nervous about your privacy rights.
If the court goes the way you suggest and proposes some limits on the third-party doctrine, how far do you think they will go? Because the other standard advice is not just turn your phone on airplane mode, it's don't talk, right? If you're going to go around the Radio Shack, don't tell someone. Because if you tell them, they could go right to the police and share that information with them. So how far will the court go in the kind of privacy rights here? Is it just because it's digital in the one case as opposed to words?
I think it's going to be very hard for the court. You could tell they were struggling. There's some property rights ideas about how I still have a property interest in that information I've turned over to Verizon. There's some idea that location data is different than other data. There's some idea that it's a kind of mosaic theory, that if the government gets too many that each individual dot of information by itself is not a problem, but if you put them all together. But you can tell as I'm rattling off these ideas that none of them is wholly satisfactory. And it's going to be hard for the court. And as you point out, If someone sees you on the street and you're robbing the Radio Shack, you have no rights as against that person. They can say what you did. And why is it truly different that Verizon, in a sense, sees where you are?
This is maybe a case where Justice Kennedy is not in the middle, because the justices in Jones, the GPS case, have combined in ways that are less than predictable. But he said that perhaps in these type of cases, it's not us who should decide this, it should be the legislature.
Oh, I think every serious person agrees that this is a job for Congress. But I also think every person who's awake knows that saying to this Congress that this is a job for Congress is not necessarily going to get you a good outcome.
And one last question on this. I found it interesting that Apple, Facebook, Google weighed in supporting Mr. Carpenter's case. So what stake do they have to argue for greater privacy protections in a criminal case like this in the kind of cell phone, historic cell phone location data?
So I think the tech companies do a pretty good job protecting your data as against the government and outsiders, and a pretty bad job protecting your data as against them. So they try to have it both ways. They'd like to use your data, monetize your data, and have a field day. But they also think it's good for business to be able to tell you, listen, you can use my product and the government's not going to know what's happening.
Yeah.
Let me come back to Justice Gorsuch briefly. We've seen over the past 14 months several instances where the president has attacked the judiciary, before when he was in the campaign and since when courts have ruled against him. Justice Gorsuch, when he was going through the confirmation process, told a senator that this was distasteful, that this remarks from the president were unseemly. And then he caught a lot of heat from this from the president for expressing this. The president suggested that maybe he wasn't loyal enough, and the reporting was that perhaps the president was considering withdrawing the nomination even at that time. So what role, if any, does the court have in responding to the president's, sometimes it's in a tweet, sometimes it's a statement, where he attacks the independence of federal judges or the judiciary in general? Does the court hear those attacks, and what, if anything, can we do about them?
The court is well aware of the attacks. The attacks are deeply problematic. In recent memory, they're unprecedented. They do damage to the rule of law, but they put the court in a real bind. I don't think the court, the justices, the Chief Justice, wants to pick a fight with the president over this stuff. They want to put their heads down and do their jobs and decide cases on the merits. And I think they're probably afraid that it would only dignify and amplify this kind of comment. And that given the constraints under which the justices have to act and the complete lack of constraints under which the president acts, it's not a fight you can win. And we're also heading into an era where it's entirely possible. I mean, we're going to have the travel ban case argued in April. Other cases arising, perhaps out of the Mueller investigation, may well reach the court. The court needs to preserve its institutional authority because it may be heading into a real showdown.
If those cases come, is it out of the question, given what the president has done with other senior officials, expressing a desire for loyalty from Comey, for example, is it out of the question to explore whether he requested something similar to Justice Gorsuch? He reacted very forcefully when he felt that Justice Gorsuch wasn't demonstrating loyalty, when he thought it was distasteful that the president attacked individual federal judges. So should journalists be trying to find out if a similar question was made of Justice Gorsuch during the nomination process?
Yes, sure. He was asked more or less that question during his confirmation hearings. And I believe Justice, and I've talked to folks in the White House counsel's office too, I don't think that kind of interaction happened. I do think that the president has an odd view of judges and may think that they owe him something But I think whatever criticism has been leveled against Justice Gorsuch, I don't think there was any commitment questioning. I don't buy that for a second.
One of the cases that the court has put off in the last, I think, 4 conferences is a case right here from Arizona. It's Hidalgo v. Arizona. It's a capital case, and there's basically 2 questions before the court, and they're very clear questions. The first is a challenge to Arizona's capital sentencing scheme because essentially all intentional murders qualify, at least potentially, to be capital cases, leaving the prosecutor's discretion unfettered. But the other one, the more important question, I think, is an example of the justices signaling, or at least 2 justices signaling, they might be ready to take on capital punishment as a facial challenge. The case will be at conference again, I think, later this week, but they put it off 4 times. Is the court ready to re-engage with a wholesale challenge about capital punishment or not?
The court's not ready, and if the court came to be ready, opponents of capital punishment should be nervous, because I don't think there are 5 votes on this court to do away with capital punishment. When the court relists the case for a second conference, that makes it more likely that they're going to do something. But as they relist it for a 3rd and a 4th, it makes it likely that someone is writing a dissent from denial of the kind I talked about before. Justice Breyer has really made this his cause. He thinks the court should re-examine the constitutionality of the death penalty. Justice Ginsburg has joined him in those dissents. I think it's likely that Justice Breyer is writing again on this point. He really cares about it. But I wouldn't even be confident that the other liberal justices, the newer justices, Kagan and Sotomayor, are on board. And I don't think Justice Kennedy's on board. So I don't think the court's going to take that question. If the court did take that question, I don't know that people who oppose capital punishment should be happy about that. As to the first question about Arizona's sentencing scheme, that's the kind of question they might well take. I don't remember the facts with great particularity, but the idea is that in order to be sentenced to death, you have to have not only done a murder, not committed a murder, but also have some aggravating factors. And Arizona's list of aggravating factors is so long that basically this doesn't make it likely that you're going to get the worst of the worst. You're going to pick up everybody. On the other hand, as I recall, but you probably know better than me, Jason, this guy Hidalgo was an ugly character. He was convicted of having committed a murder for hire, and in the process of the murder for hire, also killing a bystander. So in the legal papers, Arizona said that one murder was free and the other was complimentary. This is not the poster child for reform.
I think that's right, and I have my own hesitancies when the case was brought to the court, but Hidalgo's attorneys, right, they're just trying to do anything they can do to help him. But I'm interested in Justice Breyer. Presumably he has a good sense of where his colleagues are as well. So do you think he realistically thinks that the court is ready, or is he just trying to talk to them through his dissenting opinions to lay the foundation for what might happen a decade from now?
Justice Breyer thinks of himself as highly strategic. And I think in general he's pretty good at it. I think on this one, he might not be analyzing the situation the same way others would. He was also on the court the last time around. Not on the court. He was a clerk on the court the last time this situation came up. And he saw the justice he was clerking for, Arthur Goldberg, take the lead in trying to take on the death penalty generally and have it held unconstitutional. And the court did get pretty close, and there was a 4-year moratorium. So I think he has the lived experience of this being a possibility.
Are there some cases before the court now that either haven't been argued or have been argued that aren't getting the attention that we might think they deserved if we look back 7 years from now at this term, that somehow we haven't given them the right care or attention now, and they might turn into blockbuster cases that we just haven't anticipated?
Well, one of them is going to be a blockbuster and is a foregone conclusion. The court will, in a couple weeks, hear again a case that will likely deal a severe blow to organized organized labor, will allow people who choose not to join public unions not to pay fees for collective bargaining and other activities on their behalf. And if that happens, and it's very likely to happen, that will make public unions weaker again. We know this is likely because the court 2 years ago heard almost exactly the same case, was poised to rule 5-4 against the unions, and Justice Scalia died. Justice Gorsuch is going to vote as Justice Scalia would have, and that case will be one of the big cases of the term. The travel ban case is a big case. There's a ton of interesting First Amendment cases this year. One about whether so-called crisis pregnancy centers, where women go, some of them thinking they're going to get help getting an abortion, but in fact, these are places run on religious principles, and they try to talk women out of having abortions. And so California, unhappy about what it sees as a misleading way of doing business, forces these places to put on their walls, if you want an abortion, the state will help you, and here's a phone number to call. And the First Amendment question in the case is that compelled speech? Can you force someone to say something that they don't want to say? And that frame of compelled speech, you see it, we haven't talked yet about everyone's favorite case, Masterpiece's Cake Shop. That's compelled speech. Can I be forced to bake a cake I don't want to? If it's compelled speech to support a union whose activities I don't want to support. It may be compelled speech for these crisis pregnancy centers. And then there's also a great case out of Minnesota I love about a dress code for voting. Can Minnesota ban people from wearing political t-shirts, hats, and buttons as a condition of voting?
The voting case from Minnesota made me think of another voting case, this one from Ohio. So Ohio has been fairly aggressive in trying to limit the voting rolls. If you don't vote in a federal election one time, they'll send you a notice, and if you don't respond, then they'll take you off the rolls. And the challengers have questioned whether this is a larger attempt to limit the right to vote more broadly across the country. What's at stake in the Ohio case? There are other states who have a similar law but are less aggressive in policing their voting rolls. What will happen if the court either permits or limits what Ohio is doing right now with respect to their rolls?
So the big picture is that in the current environment, Republicans would rather have fewer people vote and justify that by saying there's a problem with voter fraud. Democrats would rather have more people vote and say what the Republicans are doing is voter suppression. The Ohio case arises because Ohio, and this is not crazy, wants to clean up its voter rolls, wants to make sure there are no dead people on the rolls, wants to make sure that if you move out of state, you're no longer on the rolls. And that's a good thing. I mean, the voter rolls ought to be kept current. There's a federal law that says you can and should clean up your voter rolls, but you can't kick people off the voter rolls solely for not voting. You're allowed not to vote. You have a right to vote, you also have a right not to vote. There are a lot of people who are not happy about some of the candidates, and they stay home. Ohio, as Jason was saying, sends you a postcard and asks you to return it. Are you still there? Do you still want to vote? Does that run afoul of you can't be kicked off the rolls solely for not voting? The answer is statutory. The outcome, nonetheless, sadly, will almost certainly be decided along partisan lines, with the 5 Republican appointees on the court going one way, the 4 Democratic appointees going the other way, lining up in the big picture way I was suggesting. And that's a pity, because the statute is confusing. You could argue it backwards or forwards, but I hope I'm wrong, but I think that in this area, not every area, but in this area, the court might line up in a partisan configuration.
Let me touch on one other case before the court, and then I'll open it up to questions. I think we'll have time for a couple questions from the audience. But I did want to talk about another criminal case from this term that is a capital case from Georgia, Tharp v. Sellers, that partnered with the case from last term, Pena Rodriguez from Colorado. So in each of these cases, the court elected to look into the jury room to figure out if the jury was basing its decision on racial animus. Now, the historic precedent had been that the jury is a black box. We're not going to investigate what they talk about when they make a decision. We're going to protect that, and we'll just hear their verdict going forward. Last term in Peña v. Rodriguez, they said, we'll make an exception. And they didn't really know how big the exception would be, how to cabin it off. This term in Tharp v. Sellers, they stayed this capital case to allow Mr. Tharp to make a claim that his jurors used racist views when they were elected to sentence him to death. So it can't be that the court now believes that jurors are doing this and they hadn't done it in the past. Why is it that the court changed the course of decades of precedent to allow us to look into the jury room in this one area now, when certainly they knew that this was going on in all parts of our country's history?
In dissent in the Tharp case, Justice Thomas, joined by Justices Alito and Gorsuch, wrote that this is all ceremonial hand-wringing. And I think there's an element of truth in that. It's fairly hard to come up with even a little bit of evidence that a jury has been tainted by racism. And there's still all kinds of hurdles you have to overcome to get a verdict reversed. Mr. Tharp, I mean, the facts are so ugly I hesitate to say them. He said that he had based his decision partly on his understanding that there are two kinds of black people. There are nice black people and there are people he used the N-word to describe. And that he doubted, in fact, that black people even have souls. And he signed an affidavit to that effect after voting to sentence Mr. Tharp to be executed. And in the face of that kind of evidence, the Supreme Court, and you know, and Tharp is still going to lose. There are 15 different hurdles you have to overcome to get his sentence turned over. But in that kind of setting, I can understand why even the Chief Justice and Justice Kennedy are going to go, listen, we want no part of this. We want the American public to have faith in the criminal justice system. We don't want it to be stained by obvious, ugly racism. But the ceremonial hand-wringing point from Thomas is also correct, because it arises in a habeas context where he's just not going to get from here to there. And also, he was also almost certainly guilty of a very, very ugly crime. What was kind of interesting there was that unlike the first case you talked about, Peña Rodriguez, that was 5-3 before Gorsuch came on, and the Chief was in dissent. Here, even the Chief seemed to want no part of this. Peña Rodriguez was about a juror who apparently said that illegal immigrants and Mexicans can't be believed. Both of these cases arise from quite old facts. This kind of evidence doesn't come up very often. I think the Supreme Court, or the majority in these two cases, makes the judgment. We don't want to send a message that we tolerate this stuff, but nor are we afraid that this is going to happen every day. Coming up with this kind of evidence is rare. I'm not saying that there are not racist jurors, but I don't think there are a lot of jurors who are, stupid enough to be signing affidavits of the kind of things described.
So if there are any questions from the audience, I think we have time for a couple of them. Yeah.
Thank you. In the Ninth Circuit, in a case called Peruta, which is a right to keep and bear arms case, and also in the Fourth Circuit in Maryland, the circuit courts have been doing a pretty good job of running away from the 2008 Heller decision. In fact, they're almost setting land speed records doing it. And the Supreme Court seems somewhat reticent to review it even when there's splits in the circuit. Can you address A, what effect that may have on people's confidence in the courts, and B, why is the Supreme Court trying not to touch some kind of a hot poker?
Yeah. That's a terrific question, very interesting question. So the Supreme Court in 2008 revolutionized Second Amendment law, said you have a personal right to bear arms, at least to own guns for self-defense in the home. And then in 2010, it expanded that to the states. And then, having established this new constitutional right, it goes quiet. And astoundingly, it keeps turning away case after case after case. including cases where you could really plausibly say that the lower courts are disregarding these 2008 and 2010 rulings. And I don't know what to attribute it to. It drove Justice Scalia crazy. It drives Justice Thomas crazy. It says we've established a Bill of Rights right, but it's a second-class right. And, you know, people really ought to have an answer to the question, for instance, okay, I have a right to bear arms for self-defense inside my home. Does that apply to outside the home? Does that apply to public carry? And the courts are giving us different answers. And the only reason I can think of that the court doesn't want to get involved, well, two of them. One, I think even the middle of the court, the Chief Justice and Justice Kennedy are nervous about giving this right real teeth. And I think the court is also nervous about announcing an expansion of the constitutional right on a Monday morning and having a school shooting on a Monday afternoon, just after the court.
Could you tell us a little bit about your life as a reporter covering a legal beat? How has your job changed from when you were covering a sort of a general legal beat to covering the Supreme Court? What are the biggest differences? What do you miss about the older job? What's exciting about the newer job? Could you just reflect a little bit on what's like as a reporter covering those beats?
The old job was a great job. I roamed the country. I found stories nobody else was writing about. I opened windows onto larger legal issues. I wrote series about people serving life sentences and campaign contributions to state Supreme Court justices. I thought I had an impact. I had that thing journalism likes, which is being distinctive. I had the occasional scoop. Then I moved to Washington 10 years ago, and I'm writing about cases that 9 old people in robes think I should be writing about. That a very good press corps covers. Very hard to write things that are authentically distinctive. Very hard to get a scoop. And then layer on top of that, that since I've been there, the need for speed has accelerated to a point where, you know, when I went down there, I said, well, I'll tell you one thing, I'm never going to write about a decision before I read it. Those days are gone. I'm routinely in a big case. I will pre-write various versions. I will glance at the who won, who lost, slap a lead on top of that, push a button. That will get an enormous readership. In the course of the day, I'll write a pretty good story. The next day's paper delivered to our 4 remaining subscribers on the Upper West Side. We'll write a very nice story in it, and there will be a complete inverse relationship between readership and quality. So the first story will be read by millions, and the final story will be read by, you know, those 4 remaining people.
What do you think is going to be the outcome of the marijuana approval by so many states and the sessions saying that we're going to prosecute people that have marijuana more vigorously?
You know, I know a lot about the Supreme Court and very little about the Justice Department. So I imagine that we could take Jeff Sessions at his word that he's going to try to do something and there will be a real federalism clash. And bear in mind that it used to be that the Republican Party was pro-federalism, was pro-letting states try different ideas. But I'm getting out of, you can tell, I'm already out of my depth.
I think we have time for one more question. Yeah, the second row there.
Pennsylvania Supreme Court yesterday released its opinion explaining its ruling on gerrymandering. As I understand it, the opinion can serve as a roadmap for many state courts to reach similar results in similar circumstances. But I'm wondering what you think the impact of these decisions is likely to be on the Supreme Court and its consideration of gerrymandering. Does it have to find them persuasive, or does it have to find them something we can do for the states?
Let me just repeat the question quickly. So the issue before the Pennsylvania Supreme Court was about where we started this evening with gerrymandering in state there. The difference is in this case, the Pennsylvania Supreme Court issued its opinion based on the state constitution, not the U.S. Constitution. So whereas North Carolina's case, also about partisan gerrymandering, the Supreme Court stayed presumably to deal with the Wisconsin case. Here, they let the Pennsylvania Supreme Court go forward. So the questioner is asking about whether the Pennsylvania State Supreme Court opinion might be used in either other state courts or might be influential before the Supreme Court.
Yeah, I think so. I think that's a good point. The Supreme Court declined to hear an emergency stay on the Pennsylvania Supreme Court. Didn't say why, but presumably because state courts are allowed to decide state constitutional issues, and they have the last word, and that's federalism. And that's even so when they're drawing maps for the U.S. Congress. So that will certainly send a signal to other state Supreme Courts that they could insulate from review cases on gerrymandering and other cases, so long as they base it solely on the state constitution. And I think that could be a model, and it will make a difference. Now, here again, there are many people who think the Pennsylvania Supreme Court made the right decision. That's a case in which Republicans gerrymandered the congressional map to get more seats than you might think they deserve. But I'm sad to say that Pennsylvania Supreme Court justices are elected on partisan lines, and the vote was 5-2, and then 5 Democrats in the majority, 2 Republicans in the minority, and it would be a better world in which I wasn't able to say things like that.
Please join me in thanking Mr. Liptak and